I'm Sorabji, and I'm the module convener for the Principles of Civil Justice course. The module focuses on the principles and different approaches to the delivery of civil justice, which is effectively the means by which we vindicate and enforce our civil rights. What does the course look at? Well, to start off with, the course focuses on general principles of what is known as due process. What goes to make a civil system fair? Is it effective participation? Is it equal access? Is it something more than that? What are the various aspects which go to make a fair process? Having looked at that, we move on to looking at the aim of the course. Historically, different approaches have been taken. On the one hand, a court's process could be to secure absolute compliance with its rules. Is that the right approach? The general approach across many different jurisdictions over many years has been to secure substantive accuracy, as it's called, the correct decision on the merits of the case. We look at that. We also look at moves away from that approach over the last 10 to 20 years, in particularly common law jurisdictions, where limits have been put upon the court's ability to find substantively correct decisions. We look at what is known as the development of proportionate justice. Having looked at that, we then look at discrete areas of the civil process. We look at, for instance, the development of case management, court control of litigation, and the problems that gives rise to, both for parties and the courts. We look at interim relief, how courts ensure that their processes are not frustrated before final judgment is given. So we look at injunctive relief, for example. We look at evidence, whether that's expert evidence or documentary disclosure, a particular feature of common law jurisdictions. And we look at exceptions to the disclosure process, whether that be legal professional privilege or, for instance, the privilege against self-incrimination. We then turn to look at a constant favourite of civil proceduralists, the development and problems associated with class actions, multi-party litigation. Having looked at those general points and general issues, we look to perennial complaints. The first perennial complaint is excess litigation cost. Why does it arise? What problems does it cause? What are its effects? How do we tackle it? Why have attempts to tackle it and reduce excess litigation cost failed historically? We then look at the obverse of litigation cost. We look at litigation funding, public methods, private methods, and we look at the shift over the last 20 years or so from public legal aid funding to private sources of funding, and the issues that that gives rise to. Finally, in the last 2 weeks of the course, we look at contemporary issues, recent developments. So, for instance, we're currently looking at the development of online justice, digital courts. What issues does that give rise to for due process principles? How do you have, for instance, an open court process if the hearings are carried out online? How do the public gain access to online hearings? How do we ensure that the online process is kept up to date? We also look at, in this regard, the promotion and the potential privatisation of civil justice systems. What effect may that have on the rule of law? What effect may it have on the role that courts play within society? So that's the course in a nutshell. What does it involve in itself? Well, the first thing to say is that it involves a degree, as you would expect, of independent learning. The independent learning, however, is reinforced by 22-week seminar classes where the issues each week are explored in more detail than is set out on the reading lists. The course is examined by a 3-hour written exam, and throughout the course you get opportunities, if studying it, to produce formative essays, practice essays, through which you can hone your critical skills, your analytical skills, and receive feedback. Who teaches the course? Well, as course convener, I teach all but 1 week of the course. The 1 week when I don't teach, a special lecture is given by usually a member of the senior judiciary in England and Wales. Historically, that has been, for instance, Lord Newberger, the President of our Supreme Court, or Sir Peter Gross, the former senior presiding judge of England and Wales. and they tend to deal with topical issues of the moment, whether that has been judicial independence, changing judicial roles, for instance. So it's a combination of teaching and special lecture. In a nutshell, that's the Principles of Civil Justice course. Thank you very much for listening, and I hope to see you in September.